right, I guess we can start finally. So good afternoon, everyone. It's incredibly great to be back to Rome again. It's our third time at LAIR as ACTECON team. And today we have a great panel and a great topic to discuss. In fact, I should confess that we had some, let's say, small troubles in choosing the topic. Third time in a row to come to such festival, you know, you kind of have a author's, how you call it, breakdown kind of thing, you know, because there's so many topics to discuss, but they want to pick. So we stopped at the one that I think never gets out of fashion and always actual, right? So the gun jumping. And I'm sure many of you can relate, especially if you're the practitioner, the scenario when at least once in your practice you've been asked by the client to weigh the situation of the corporate urgency of the deal and the strict approach of the competition authorities. In other words, which one, to answer the question, which one is going to be more costly? To wait for the clearance and potentially, let's say, face some contractual penalties if the clearance comes late, but still remain compliant, or not to wait for the clearance and close the transaction earlier, but then, you know, you may avoid the contractual liabilities, penalties, but nevertheless you may be faced with the gun jumping fines. So this tension, say, of the urgency of the deal, right, on the one side, and the strict approach of the competition authorities that requires the full compliance with the standstill notification and the standstill obligation, is something that, you know, very relevant in everyday business activities. And this is something that we would like to elaborate today in our great panel with representatives from Europe, US, UK, and Turkey. So Alessandro will cover the approach to gun jumping in the EU. Then we have Franco, who will be dealing with the US approach. Turkish peculiarities of the enforcement of the merger control rules as particular approach to gun jumping will be covered by Bahadur, and Saskia will bring us some flavor from the United Kingdom. So if, you know, for the sake of the time, let's structure it the following. Each of you will have approximately 8 minutes, and then we'll have a quick, you know, touch-up of the practical guidance, practical advice that you may wish to give. So Alessandro, let's start with you, particularly with the impressive fines that we've witnessed in the European Union, right? We would like to hear, let's say, the latest trends of the European Commission's approach, maybe a little bit on the Illumina Grail case, particularly with regard to the fines that the target was actually fined. So yeah, the floor is yours.
Thank you, Anna. So indeed, a hugely relevant topic in practice in the M&A context, gun jumping, and that is so also within the European competition law framework, as well as within the member states. And there are many factors confirming or dictating their importance. First of one, you already recalled it, it's the relevance, increasing relevance and importance of the fines. And certainly the Illumina Grail fine comes to mind with an application of the maximum statutory fine. But I think not only that, if you look at national level, we've got a recent decision in Austria of 70 million euro, which was increased by the Supreme Court. So even that shows that even a member states level fines can be very high, as also the French experience shows in the past with the fine against the Altis some years ago. Then clearly the importance of the gun jumping topic within the EU is confirmed by the pending investigation regarding the Vivendi Lagardère transaction, which happened already 3-4 years ago, and that shows clearly that the Commission is not shy about pursuing a gun jumping case, even if that goes back to some years. And the case clearly was about early influence on editorial choices. And so it really goes to the core of the practical questions which we face as council when advising companies in those circumstances. Once again, at national level, we see a good number of cases. Arguably, the Spanish authority is one of the most active ones. There is even an ongoing investigation now in the hospital sector. We've seen a few weeks ago a fine in Denmark. So it's still a developing and active context. And that is ultimately dictated by the fact that the appetite for synergies, efficiencies in the M&A context, and the ambition to realize those synergies as soon as possible really pushes parties to try to achieve, to explore those opportunities as soon as possible, thereby triggering activities which can run afoul of the gun jumping prohibition. So for clarity, clearly the purpose today, is really to focus on the early implementation of the transaction as opposed to the mere omitted filing. But in the European Union, the two things are really intertwined, and the reason for it is the way the law is written and the way the law has been applied. So as you know, there are two prohibitions, two infringements which are envisaged by the UMR. One is related to the failed filing, and the other is relating to the early implementation of the transaction. But the relationship between the two infringements is asymmetrical, because every time you have a omitted filing, you also have an early implementation of the transaction, because it's only at that point in time that the omitted filing becomes relevant. And so the practical consequence is that in most cases, we've actually seen two fines rather than one. Clearly, there's not today for discussing about the nebis in idem possible violations, which have been, as you all know, excluded by the Court of Justice. But I think a quick remark is still that that doesn't feel like a satisfactory approach in terms of fining, because the very basic fact that two identical fines are issued for the two conducts, or that the same fine is split in two, just gives you the feeling of lack of really tailoring, of adjusting the fine in light of the actual conduct. And that becomes even more clear when you think that most of the cases, perhaps except the Lumina Grail case, were not really about parties having missed a filing or the filing obligation. It was about not having properly drawn the line of what they could do and they could not. So that really leaves you with the fact that clearly the center of the seriousness of the gravity of the conduct was not really about having not filed. It was really about the early implementation. So the approach is still unsatisfactory, which is also related to the fact that, generally speaking, at European Union level, one may argue it's hard nowadays to miss a filing. But one wonders whether that's supposed to remain the same. That may well change for many reasons and many fronts, which may increase difficulties of even identifying major filings, and so the risk of let's say, the procedural gun jumping aspect. And for instance, the increased relevance of collaboration agreements, both in the industrial sector as well as we've seen recently in the AI sector, suggests that the line between agreements and concentrations may blur. So that's a further angle to keep into consideration from a gun jumping perspective in terms of omitted filing. Turning quickly to the point really of the red flags about early implementation of a concentration, I think the general perception is still of a lack of guidance. We've had important judgment, we've had important decisions, but the general perception is still one of lack of guidance by the Commission. There's no soft law, there's no guidance about this, as opposed to what you see in other countries, such as Brazil, China to some extent. There is something in France and in the US as well about the pre-integration planning activities. So there is something missing there. And when you look at the decision, at the judgments, I think overall there's a tension. There's a tension between the statements of principle which you find in the important EY judgment, where really everything, the guidance is centered around control, concentration. So the notion of acquisition of control as the guiding light as to what I can do and what I cannot do in terms of early implementing a concentration. And in that context, both the decision and even more forcefully, the Advocate General was very dismissive about other concepts, other legal criteria, which are instead very relevant in legal practice. So the concept of merger specificity of an act, which you implement in the preparation, it was dismissed by the Advocate General in why, but in practice, when we advise companies, that's really an important criterion, although it's not the end of the story. Then the irrevocability of a conduct is also a very important concept, and it often ends up really being the key concept, because there are certain activities which could be somewhat anticipated without really putting any consequence on the market, and like activities which can be reversed back, such as, for instance, preparation of or even partial initiation of activities in changing, I don't know, the accounting methodology within the firm. So there are activities which can be started. I think, I mean, also given the limited time, really, as most know, really the drawing line eventually, ultimately remain that of the distinction between preparation, planning, and implementation of the future integration. That is somewhat of an open concept. It is somewhat unsatisfactory from many standpoints, but ultimately it's what we have today in terms of general guidance. And that means that really, in order to approach these issues in the safest way, what is really key is to have a proactive approach. So it's not just about writing down the covenants in a proper manner. It's about really identifying from the outset what are the areas of possible early exploration of the future concentrations which the parties are willing to explore. The information of exchange is instrumental to that. And so it's really about proactively designing a system from the outset in order to monitor and control those risks, rather than having a reactive approach when the issue arises, because but by all means that will probably be too late when that happens. And I think I can pass on.
Thanks a lot, Alessandro. Indeed, just want to point out about this thin line that you are mentioning about the preparation and early implementation. It's very difficult to kind of the subtle issues that are related to the de facto control that actually this is the point, the major point where the gun jumping gets very tricky. All right, so moving on, Franco, turning to the United States, right? So can we say that the enforcement against gun jumping has been intensified, or like other more cases, or like in general, like what's the current trend in the US?
So first of all, I'll start with a little bit of good news from the US. Having heard the numbers that Alessandro mentioned in terms of fines, I can report that the fines in the US are pretty modest. We're talking about, $1 to maybe $3-4 million. Nothing like the Illumina Grail fine or the fine in the Austrian case that you mentioned. So it looks like the US has some catching up to do in terms of fines. So briefly to address your question, I don't think we're seeing a real pickup. There's been pretty steady enforcement of gun jumping rules in the US since the early 90s. There haven't been many cases. I think, there's been a dozen cases at most in about, 35 years. So it's not a very active area of enforcement, but it is one that is important. We saw pretty significant hiatus since 2017 to 2024, and maybe because companies have gotten better at complying, or maybe because the enforcers were less interested. But there were two cases in 2024, 2025 in the span of 6 months, and that led to some speculation of, a potential enforcement uptick. But we'll see if that happens. Obviously, we have regulators at the FTC and DOJ now that appear to be more lenient in terms of enforcement than what we had before. In terms of the type of cases that we've seen in the U.S., I think it's pretty clear that the issues that have come up in the past are focused on two areas, the obvious areas of what we call excessive pre-closing coordination or premature integration, which is the issue that Alessandro mentioned, where two companies have entered into a merger agreement, and in connection typically with integration planning, they end up doing too much, either because they do actual implementation as opposed to just planning, or they exchange too much information in connection with integration planning. So that's a typical area of enforcement. The other area that comes up all the time is the interim operating covenants between the two companies in the period of time between signing and closing. They will agree that the buyer has certain rights during that period of time, typically to protect the value of the company that they're buying, say, restrictions on acquisitions that the target company can make. But sometimes those covenants go too far and they end up covering ordinary course activities, and that's a typical area of enforcement. I think what we've seen in terms of cases and also guidance from the agencies is a clear focus on egregious violations. We haven't seen cases where there were marginal conduct that could be, called into question. The type of cases that we've seen in the US involve situations where, just to give you some examples, coordination between the buyer and the target in terms of shutting down target factories between signing and closing and move the customers to the buyer, which seems pretty egregious. Interim operating covenants requiring the target to seek approval from the buyer for price changes, discounts, entering into contracts with customers, hiring employees in the ordinary course of business. We've seen a case where the parties entered into a tolling agreement whereby the buyer was essentially buying all of the output of the target between signing and closing and selling it on the market, essentially replacing the target as a competitor in the market. So those are the type of egregious violations that the agencies have focused on. The two recent cases that we've seen in 24 and 25, I think they were, one, sort of a plain vanilla case, and the second one, a more interesting case, in particular in terms of the conduct that was challenged by the Department of Justice. The FTC case in January 2025 was a merger of two oil producers with overlapping activities in Utah. And in the merger agreement, they agreed that the buyer would have the right to approve any drilling activities of the target, meaning new exploration and production activities, and the buyer immediately exercised that right, in particular in Utah, where they competed with the target and stopped all of the exploration and production activities of the target, causing a shortage of oil supply in the area and immediately replacing the target's supply with their own supply. Seems like, a pretty egregious violation. Even for something like this, the fine was $5.7 million, so, a fraction of the numbers that you guys are seeing in Europe. More controversial, there was a recent case brought by the DOJ last year where the impression is that the conduct that was challenged was actually a sort of a integration planning as opposed to actual implementation. The buyer had won a contract to manage a concert venue. The target was the current operator of that concert venue, and before closing the transaction, the buyer decided that the target would continue to operate that concert venue post-closing, but nothing happened pre-closing. It was essentially a decision that, once we close the transaction, instead of transitioning the management of the concert venue from the target to the buyer, we'll just have the target continue to manage that concert venue. So, from my perspective, that seems like, pretty legitimate integration planning. But the DOJ took a different view, decided that that transaction that conduct went too far, and brought an enforcement action, fined the company $3.5 million, imposed an antitrust compliance officer, antitrust training program, and so on, so forth. So, I would say that with the exception of that case, which, from my and many other people's perspective, went a little too far. Generally, the focus in the U.S. is on, conduct that really is pretty egregious. I would just conclude with a word on penalties. As I mentioned, the penalties in the U.S. are pretty modest. It's $52,000 per day of violation. So obviously, if the violation goes on for a long time, the fine could be significant. But if it is caught during the merger review, it's usually, a short period of time. And so what we've seen is penalties in the range of from $1 to $6 million. But I think the most important issue to keep in mind is really the fact that a gun jumping investigation can be a major distraction during the merger review and often delay the clearance and the closing of the merger. In the case that the DOJ brought recently, they got the parties to agree not to close the transaction until the end of the gun jumping investigation, which delayed the closing by several months.
Thank you very much, Franco, for this comprehensive overview of the most recent decisions, gun jumping cases. So now we're moving to Turkiye, right? Bahadur, Turkish Competition Authority has also been quite active. Do you think we can kind of relate this as well to the fact that to the amendments of the merger control thresholds back in 2021 with the introduction of the technology undertaking exception, or 22 years?
Thanks very much, Anna. First of all, I'm indeed happy to share this session with our friends and great colleagues. Alessandro, Franco, Saskia, thanks very much for being here, for joining us. This is my second year in the festival, and I would like to say that it's a great tradition. It's more than an event, a tradition, and all the compliments goes to Lear competition team. We should give all the credits to Lear team. Thanks very much for organizing this event. It's now 20 years old, so it's great to be here, to be a part of it, to contribute to it. In terms of gun jumping, in the Turkish merger control regime, I'll walk you through 3 landmark cases. Each of them actually tells a different story, but the common message is gun jumping enforcement is indeed strict in Turkey. When we look at the sanctions, there is an automatic fine, which is 0.1% of the Turkish turnover of the acquirer. Plus, if the competition is restricted, then the competition authority is authorized to restore the situation and to impose monetary fine, this time up to 10% of the Turkish turnover of the buyer. Let me continue with the cases. The first one is the famous Elon Musk Twitter deal. It has a special importance in the Turkish case law. The Turkish Competition Authority, to deal with startup acquisitions, actually introduced technology undertaking exception, a sector-specific threshold in 2022. And based on this sector-specific threshold, if a target operates in software, gaming software, digital platforms, health technologies, financial technologies, biotechnologies, pharmacology, or agrochemicals, I know it's quite broad, then we do not look for a specific turnover on the target side and needs to notify the deal generally based on the global turnover of the acquirer. Obviously, Elon Musk's global turnover was way beyond the threshold on the buyer side. Again, it was quite clear that Twitter was in the scope of the technology undertaking exception as a digital platform. However, against this background, the Twitter deal was not notified to the Turkish Competition Authority. And right after the authority figured out from the public sources that the transaction is closed without clearance, it fined Elon Musk for failure to notify the Twitter transaction. So takeaway one, if you have a technology-related deal, then you need to be very careful not to jump the gun under the technology undertaking exception in Turkey. The second case is also quite important and a big deal between Broadcom and VMR. What is striking here, the gun jumping in the Broadcom VMR deal actually uncovered in a different transaction between KKR and VMR. The question is how it happened, how it discovered. There is a specific question in the notification form, in the Turkish notification form, related to the previous transactions in the affected markets in the last 3 years. And due to this question, and not to provide false or misleading information, the parties might be under the obligation of disclosing a previous gun jumping. And this was exactly the case for Broadcom VMR. In KKR VMR notification, the parties disclosed the Broadcom VMR transaction as a past deal in the affected market. Then the Turkish authority therefore detected the unnotified Broadcom VMR deal and fined Broadcom due to gun jumping. So takeaway two, when you skip a transaction, actually you might be under the obligation of reporting the skip deal to the Turkish Competition Authority in a different notified transaction. And this may also cause a gun jumping to be detected and fined. The third one is quite recent one in fintech area between two local companies, Param, the acquirer, and Kartek, the target. Quite surprisingly, the process in this case was started with a third-party complaint. The claimant alleged that acquirer already started exercising controlling power before the clearance. And against this background, the Turkish authority made a dawn raid in the premises of the parties and discovered some proof of gun jumping. What are they? For instance, the acquirer appointed a top-level executive to the target. Secondly, the acquirer started attending the target's internal management meetings. the buyer already decided the salaries and promotions of the target staff. What else? There was a consensus, a clear consensus between the parties for joint marketing and sales activities. And the buyer was therefore attending the meetings between the target and its clients. So, message 3, takeaway 3, standstill obligations remain full force until the final clearance. Early moves, of course, align businesses, early moves to align businesses may look like implementation and end up with sanctions. As I also indicated in the beginning, the gun jumping enforcement in Turkey is quite strict, and the authority has quality tools like technology undertaking exception, a sector-specific threshold, a specific question in the notification form, and even dawn rate to detect a gun jumping. So regardless of the global profile of the transaction, or regardless of how small impact it has in Turkish markets, the parties should make a very careful notifiability assessment, considering the specifics of Turkish jurisdiction, and keep the standstill obligation, of course, until the clearance. So I may stop here, then we can discuss for the further questions.
Thank you so much. Now, so far we see kind of a convergence across the jurisdictions, EU, US, and Turkey, more or less, like with the issue with the de facto control and this kind of early implementation, right? Now we're moving to Saskia, right, where, so UK system is quite different. Can you please guide us through how the gun jumping works in this, let's say, voluntary system, right?
Yes, absolutely. Thank you so much, Hannah. Well, hello, everyone. Great to be here on this panel session to give you, perhaps surprisingly, the UK perspective on gun jumping. And also, please just excuse my horrible raspy voice, but hopefully it will last. So, as you say, Hannah, the UK regime is different. It is a voluntary regime. But as you will see, that label doesn't necessarily mean that much in practice. And merging parties still need to prepare very carefully in advance of completion. So it might just be good to start with the basics because the UK regime is a little different. So in the UK, the recently amended merger control regime, thresholds under which the Competition and Markets Authority, so the CMA, can assert jurisdiction are the target's UK turnover is over £100 million, or a market share of 25% or more in the UK is created or enhanced as a result of the transaction. Or third, there's now a more recently introduced threshold, which came in with the Digital Markets Competition and Consumer Act, where one party only has a UK turnover of over £350 million and a share of a market, and that can be any UK market, of over 33% or more. And the other party just has to have a UK nexus, and that's obviously sort of to capture killer acquisitions. There is an exemption if both parties have under £10 million turnover, but as we know, the UK merger control regime is voluntary. So parties that meet or exceed these thresholds do not have to notify their transactions. They are free to complete their deals, and they're not obliged to put in place standstill obligations or provisions. But of course, life is never that simple or straightforward, and the parties really do need to plan and strategize from the outset. There is one kind of exemption to this now, which came in recently with the new Act, which deals with firms that have strategic market status, which was to deal with big tech. There's been a mandatory regime introduced for that, but I'm not going to talk about that aspect today. So when you've got a normal merger outside of big tech, what powers does the CMA have? And this is where it gets quite interesting. So the CMA has the power to investigate completed mergers and decide whether to refer that merger for an in-depth phase 2 review for up to 4 months after the date of completion of the transaction or the date that material facts of the merger become public, such as a press release or announcement. So during phase 1 of an investigation by the CMA, there is no automatic obligation to suspend implementation of the transaction, and automatic prohibition only comes into place in phase 2. The CMA does have powers to impose what are called hold separate orders to prevent preemptive action being taken both for completed and uncompleted transactions. Therefore, transactions that are still in progress can be subject to these initial enforcement orders, or IEOs, to prevent integration of the business or the exertion of control over the target by the proposed acquirer. So this essentially means that the target business and the purchasers acquiring competing business need to be held and operated separately for the duration of the CMA's review. And complying with these obligations is often very costly and onerous, and IEOs are always pretty much almost imposed on completed mergers. So under the Digital Markets Competition and Consumers Act, which came in last year into force, the CMA's sanctioning powers have actually been considerably strengthened. So breaching IEOs can now result in civil fines of up to 5% of worldwide turnover, daily fines for ongoing non-compliance, and even criminal sanctions for individuals in serious cases. And breaching an IEO, I don't know, is that a form of gun jumping? Very possibly. So just to give a few examples, because I know we're a bit short on time, in 2017, the CMA opened an investigation into Vanilla Group, which was acquiring a business which provided clothes, drying and washing facilities to student accommodation providers. And so here the CMA opened the investigation into the completed transaction, which ended in both the prohibition and unwinding by divestment of the deal. And then Vanilla Group was also fined by the CMA £120,000, so quite a small amount, for breaching the IEO. And the CMA actually already then got some criticism for that because it was a small deal. I mean, the party's turnover was, I think, less than £3 million. It was a really niche market, but still, the CMA persevered. So in 2019, it then fined PayPal for breaching an IEO in its acquisition of iZettle, and gave them then the record fine of £250,000. But this was then superseded, oh no, it gets better, in 2022 when Meta was fined £1.5 million for breaching the terms of an IEO in connection with its acquisition of Giphy for failing to notify the CMA of key staff resignations. And then in 2022, JD Sports and Foot Asylum were fined £4.7 million. And this was a fascinating story, which you must read, where the CEOs met and exchanged commercially sensitive information. I think it was in the back of a car, in breach of an IEO and for failing to inform the CMA. The CMA also has the power to send out requests for information to parties and to call in mergers that it considers it may have jurisdiction over. And overall, the CMA has taken a very strong interventionist stance on merger control enforcement. So I think kind of it means this voluntary regime probably hasn't really felt much like one. But as alluded to in the previous panel, I think the tide in the UK is beginning to turn because of government intervention. So carrying out a careful risk balancing exercise when determining whether a transaction meets the thresholds will be crucial for the merging parties, given the CMA's very active mergers intelligence unit. And the MIU, as it's also called, scours the markets and has numerous touch points with various regulators around the world, including the FTC, DOJ, and within regulators at the UK as well. And of course, you know, complainants can complain to the CMA about forthcoming mergers and ask the CMA to look into it. So really then it just comes down to what is going to be the best approach when you're trying to devise whether you should notify or whether you shouldn't. And I think I'm going to just cut down what I was going to say about that now, just because of time. But basically, I think it's something that has to be taken very carefully and seriously. And there is a mechanism which you can use in the UK, which is called a briefing paper, where if you're near the thresholds, you just meet them, and you don't really think there's much of a competitive assessment which shows a substantial lessening of competition. It's a really useful tool to have a discussion with the CMA, put your narrative forward to the CMA, and also it starts that clock, which is really important. So I think just from my perspective, probably those are the main points I wanted to put across.
Thank you so much, Saskia. Some very interesting cases, and indeed, like, you're not quite sure, I'm not quite sure what's better, a voluntary regime in the UK or a compulsory one, let it be. But anyway, you very smoothly kind of already answering my question that I was about to ask all of you, this way, very 1 minute each of us. So if you are to give one piece of advice, let's say for the companies preparing merger, what would it be? Try to pick one, let's say, most important one, if you can.
I'm happy to start. So I will just make a clarification. In my presentation, I did not talk about the failure to notify cases, of which there are dozens and dozens in the US. So I was focused on the situation where there is a notification and pending clearance, parties do something that they're not supposed to do. In terms of failure to notify, I didn't cover that, but I didn't want to give the impression that there are a few of those, because there's actually a lot in the US. In terms of a piece of advice, I think, you know, based on the cases that we've seen in the gun jumping area, I would say that for, you know, lawyers like us representing clients in M&A transactions, I would encourage folks to carefully review the interim operating covenants in a purchase agreement to ensure that they really cover extraordinary actions, non-ordinary course actions, and they contain appropriate carve-outs for ordinary course actions. And I say this because sometimes I see clients fighting very hard for a certain right, you know, approval or consent right on certain actions. They finally get it, they sign the agreement, and coming in after that and telling the client, congratulations, you were able to get that right, but you're not going to be able to exercise it because it would be a gun jumping violation, I think is much worse than telling the client before signing, look, you know, this interim operating covenant goes too far and you're not going to be able to get it. So I think, you know, that's an area that from a US perspective is critical.
Totally agree with that, and I think the practical suggestions goes back to what I said before about the proactive approach and really designing a process from the start. And then I think another quick remark which I feel compelled to do is about Italian merger control, since we're in Italy, and also linking to what Saskia was saying, that in Italy we actually don't have a standstill obligation, so we don't really have gun jumping in the sense of early implementation, and sometimes we feel like no big disasters have happened. I mean, we've made it through after all. So sometimes we feel like maybe is this all necessary? But at the same time, we have to acknowledge that things are in a way moving in another direction, which goes to the other practical point which I want to make, which is about the fact that when you look at new regimes, the new regimes in most cases do have a suspensory rule. So that is the prevailing direction of, so if you look at FSR, clearly, although maybe in practice not so much relevant because the overlap with the UMR is significant, then when you consider FDI, most FDI regimes do have suspension rules, and the scope of FDI regimes in terms of filing obligations is even wider often than that of merger control regimes, and it catches even internal reorganization, intra-group transactions. So that's another new front of potential gun jumping risks. I think we haven't seen much of that happening yet, and the development that may not be very sophisticated for some times, but who knows? Just to say, it's another area of risk to keep in mind from a gun jumping perspective.
On my side, I have three advices. First, needless to say, put in place the strict protocols, clean-team protocols, and standstill covenants. More Turkiye-related advice: if you have a technology-related deal, then bear in mind that there is a sector-specific threshold, and make a careful notifiability assessment under the technology undertaking exception. And the last one, if you decide not to notify a notifiable transaction, think twice, due to the specific question in the notification form requesting information about past deals. Thanks very much.
Thank you very much, Saskia.
And of course, to end with the UK. But actually, Alessandro just made a really interesting point, because of course the UK is so complicated. So we have an FDI regime, and it's mandatory and it's suspensory, so you can't complete. So if you're also dealing in that sector, then you have to think of both of those things with merger control. But I think just my main point is, just don't underestimate UK merger control, because when it bites really hard and can have very severe consequences. And I think, sorry, just one more thing to add, is just remember that whether you have a merger or not, sharing competitively sensitive information can be anti-competitive, and that same rule applies in the UK.
Yeah, indeed. So let's say the common theme would be independence must remain real until the clearance. Okay, we are almost there. So I know we're running out of time. I actually apologize. I forgot to introduce to you from the very beginning one more member of ACTECON team, which is an artificially intelligent member of ACTECON team, Actus, that actually will summarize the key red flags of red flags before you merge. So let's see. Actus, welcome to the stage.
Hello everyone, I'm delighted to be here at LEA joining ACTECON's panel. I've had the privilege of working with ACTECON team, and it's truly special to be in Rome with them, though unlike my colleagues, I didn't need a flight ticket or hotel accommodation. Now let's wrap up by looking at the key red flags before a company's merger to avoid gun jumping. The first red flag is around management and HR. Companies must not start making decisions about hiring, firing, or staff responsibilities before clearance. Until approval, each company must remain fully independent in how it manages people. The second red flag is with customers and the market. Businesses should not begin integrating customer lists, aligning branding, or negotiating together before the deal is cleared. The safest approach is to keep commercial strategies separate and demonstrate that independence clearly. The third is operations and IT systems. Giving early access to sensitive data, IT platforms, or internal processes is risky. Information sharing must be limited, controlled, and done only under strict protocols. Anything more may be treated as premature implementation. Another red flag is in the way contracts are written. Interim covenants that give a buyer wide approval rights over ordinary day-to-day business decisions can cross the line. These rights should be carefully limited to exceptional matters that truly protect the value of the company, nothing more. Finally, timing and geography matter. Never assume that a deal is too small or too far away to trigger local rules. That's why each jurisdiction must be built into the filing strategy early on, and the standstill obligation respected until the very end. So, the message is simple. Independence must remain real until clearance. When in doubt, hold back, document your compliance, and wait for clearance before integrating. Clearance first, integration second. because credibility is harder to rebuild than cash.
Yes, on this note, thank you, actors, and thanks to all the participants of the panel, indeed, and for the audience.